Chief Executive of the Charity Commission of New Zealand to today's hearings. Before inviting you to make an opening statement, I'd like to remind you that the protection of parliamentary privilege in the Australian Parliament cannot be guaranteed to jurisdictions outside of Australia. Your evidence should be made knowing the inability of the Australian Senate to protect you outside of Australian jurisdiction. I add that these are public proceedings, although the committee may agree to a request to hold evidence in camera or may determine that certain evidence should be heard in camera. And so, having said those things, if you accept those limitations, I invite you to make an opening statement.
Great, thanks very much. Thank you for inviting me here. Obviously haven't put in a submission, so what I'm really prepared to do is simply to answer questions about our experience, but let me just give you a little bit of a background to start off with. The Charities Commission was established in New Zealand on the 1st of July 2005, so Wednesday we're having our birthday. Prior to the Commission, we had an environment where charities, in order to get their tax exemptions, would self-assess their tax status, and from time to time some organisations would write to our Inland Revenue Department and seek a letter of comfort, which simply gave them comfort that they could claim status that IRD thought they were a charity. But that was one-off and it had no legal backing. So our role is several-fold. The first that we do is to register charities. Second is that we receive annual returns from charities, which are essentially their financial statements and any changes that they've made during the course of a year. We monitor and investigate charities. We deal with complaints about charities. We make charities transparent to the extent that we publish all financial information about the charities that are provided to us, and part of that is geared towards developing an environment of public trust and confidence in the charitable sector. And the last thing that we do, which was something which came into the legislation during the select committee phase, was a move away from our regulatory role, which everything I've said so far is, but work in educating charities on governance and management. So sometimes there's a conflict between those two roles. Registration is essential for tax exemptions. So charities which had been claiming tax exemptions before our establishment, who haven't registered with us or who haven't been registered, no longer have tax exemptions, and our Inland Revenue Department is currently working through that with charities that aren't filing tax exemptions, that aren't registered. Since 2007 we've assessed something like 30,000 applications for charitable status, and we've registered around about 25,000. From the annual returns that we receive, I can tell you that around about $14.5 billion is assessed as tax-exempt income, so it's quite a significant, if you like, economic impact that charities have. And there's something like about $2.5 billion has come to charities by way of donations. So that's information which is coming out of the financial statements that are provided to us. As part of the annual returns, we will monitor charities. We'll do that on a selective basis, but sometimes what can come out of that is that we deregister charities, normally because they're not carrying out charitable purposes. So that's a process that we're going through. In terms of consideration as to whether an organisation is charitable or not, first of all, they must be exclusively charitable. So sometimes we find an organisation has some charitable purposes, but some which are not charitable purposes and which are a main purpose, one of the main ones of which is political advocacy. And then we deal with the four heads of charity, which, Chair, you have mentioned, although listening today I sometimes wonder whether we're talking about advancing poverty and relief from religion, but that's something that you can chew over. But the last part of that is that all charities must have public benefit. And when we look at that, we look at whether the whether there is benefit, which means that we will also look at whether there are harms that are caused, and secondly, the extent to which the charity is accessible to the public. So we bring in both of those tests. And since you've been talking predominantly about religion, what we use is is case law out of Australia, which has been confirmed in our own courts, which says that religion is beneficial, but we will still apply the public benefit test to that. So probably that's all that I need to say at this stage, although what I have brought over is, which the Secretariat's been kind enough to copy, is the guidance that we have on the public benefit test, which is publicly available in New Zealand.
Thank you very much, Mr. Garrett. That'll be very helpful. We appreciate your doing that. Senator Cameron?
Yeah, thanks, Mr. Garrett. Some of the submissions we've had from charitable organisations say that if we adopt the bill that's before us, that this would place a substantial additional burden on charities and religious institutions. Was that argument put forward in New Zealand prior to your coming about as an organisation?
Yes, well, it has, and certainly when we were going through the registration process, you know, we often get this thing about it being burdensome. That hasn't been our experience. For example, we found one organisation which applied online. It took something like 12 minutes to put in their application because they simply provided the rules, the list of officers, and the fact that they weren't disqualified, and ticked the boxes. So no, that wasn't an issue. And similarly, we get concerns about the filing of an annual return. And again, our experience is that isn't burdensome either. And partly that's because that's the approach that we've taken, which is that organisations are doing good, and it's not our job to make that more difficult for them. So we get sufficient information for us to be able to make a decision. I would say, though, that some organisations, when they looked at their rules, and some of them hadn't looked at them for some time, found that they were out of date. We found that many organisations had inappropriate winding up clauses, which would have made them not registerable. And so some organisations did have to go to a bit of work in order to make themselves charitable. But no, I think our experience is that that wasn't an added burden.
Many charities in Australia carry out commercial activities to fund the charitable function. How do you deal with that in New Zealand?
We allow it. So, for example, Sanitarium is registered. Many of the op shops are registered. But the test that we have relates to private benefit. In other words, if the organisation is owned by the registered charity, if all of the proceeds go to the registered charity, then we would say that was appropriate. What we would look at was whether there was private benefit, so you could look within the organisation to find whether there's excessive salaries being paid, you know, or things like that. But otherwise, we're okay with that. We accept that charities use a whole range of mechanisms to raise funds for the charity, and commercial enterprise is simply one of those.
I suppose the other issue that we've faced today and in some of our submissions is a question I've put a number of times, and how do you balance the public benefit against the actions of individuals within an organisation, and then how do you balance the vicarious liability for the organisation against the actions of individuals? Do you do that?
Well, we do to a certain extent. I mean, we've just had a recent example with our intellectual, IHC. I don't think you use the full term these days, where there was fraud within the organisation, and the person then went before the courts. Now, what we did in that case was look to see whether the organisation itself had handled that appropriately. In other words, was this something they condoned? If the answer was yes, then we may have had some issues with them. that when we looked at them, they had identified the problem, they had gone to the police, and that had been taken to the courts. So we would look at it, on the balance of what's happening within the organisation.